cold December 7th morning. Hope you're all enjoying the weather. I don't know how you would say that, since it's 9 degrees right now and the wind is howling. Hope everyone is having a good holiday season. Again, welcome to the Government Relations Committee. We're excited to have Doug Poland, the most recent past chair of the DMI Board of Directors, here to talk about redistricting. There is no bigger expert in the community than Doug. It's a great part of our team at DMI, so we're excited to have him. But as always, we're going to start with our chair, the fantastic Angie Black. Good morning, Angie. How are you?
Good morning. I'm not sure I can match that enthusiasm, but good morning. I'm Angie Black with Carlson Black. Nice to see everybody. Thanks for joining us this morning, and special thanks to Doug for doing this and being the expert on this, because I certainly don't want to dip a toe in this area. But it's good stuff to know. So thanks for joining us, you guys.
Excellent. Well, so we're going to spend the balance of the time here with Doug. At the end, I will quickly go over a few updates from the redistricting here in Madison, some changes and some alders that were shifted into other districts, and we have a quick map on how that's going to take place. So I'll go over that just on the local side. But right now, we're going to send it over to our great friend, Doug Poland, a partner at Stafford Rosenbaum and the litigation director at the new Law Forward, which has, I think, some amazing offices. We're I'm in my house right now, but normally just behind me, across the windows, we can see the great team, Nicole and Mel and Scott and everybody at Law Forward. So Doug, thank you for making them so close to DMI. But good morning, Doug. Good morning.
Thanks, Jason. Thanks for the introduction. And thank you, Angie, for the invitation to talk to the Government Relations Committee. And thanks for all of you for attending and participating. I'll just say, as a media past board chair, how important this committee is and the work of this committee, and to have those of you who are dedicated to doing this work for DMI, it's just an incredibly important part of what DMI does. So your participation is really highly valued. Thank you. Thank you for doing that. So as Jason mentioned, I am a lawyer. I'm a litigator. I do general commercial litigation. I also have been practicing for a long time, 27 years. I also, beginning about 10 or 11 years ago, started to do work in election and political law. I co-chair the election and political law practice team at Stafford Rosenbaum in Madison. Also, as Jason mentioned, a little over a year ago, I and one of my partners at Stafford, Jeff Mandel, launched a nonprofit, nonpartisan law firm called Law Forward. It really is what we call an impact litigation firm. Our goal is to try to preserve what we can of democracy in Wisconsin. And we strategically litigate cases that involve voting rights for the most part, but also involve other aspects of what's going on with government. So we're representing the city of Green Bay in the investigation by Michael Gableman. We are representing a number of nonprofit entities and voters in Dropbox litigation in Waukesha County Circuit Court, where there's a conservative group called the Wisconsin Institute of Law and Liberty that's trying to have Dropboxes declared as being in an invalid way of returning absentee ballots under Wisconsin law. We're involved in the state redistricting litigation, a host of other things that we've done too. So we're pretty active in sort of what we call the democracy space in Wisconsin. So let me jump into, I'm going to share my screen here. Let me jump into my presentation, the PowerPoint that I'll run through. I think that to the extent that there are questions, Jason or Angie, if one of you wouldn't mind monitoring the chat, and feel free to break in at any time and ask any questions. I think that's probably the easiest way to have questions. And then I'll try to wrap up so we've got 10 or 15 minutes to field some questions at the end as well. All right, so as you might or might not know, Wisconsin, and I'm going to address both state legislative districts and our local districts in this talk, so you can get an idea of the overall context. As you might be aware, in Wisconsin, we have 99 state legislative districts. This is a map of how those districts look. Not that you can tell very much from this, but as you can see, in the more densely populated areas of the state, we have more districts, and I'll get to that in a minute as to why, but we have 99 of them throughout the state. We have Senate districts as well. We have our state Senate. We have 33 state Senate districts. As you may note, 99 divided by 33 is 3. And so we have 3 assembly districts nested inside of each state Senate district. That's the way that the districts get drawn, assembly districts, and then 3 are nested inside of Senate districts. Why do we redistrict? You probably heard a lot about redistricting in the news over the past, maybe weeks, months, year or more if you've been paying attention. Why do we do it? Why do we have this redrawing of state legislative and congressional and local government districts every 10 years? We do it because in the 1960s, the US Supreme Court decided a number of cases that we refer to collectively as the one person, one vote cases. And what they essentially decided is that the United States Constitution, it's the Equal Protection Clause, requires districts from which we elect representatives to represent us in government, that they need to be equally populated. Basically, if you pack a lot of voters into one district and you have a small number of voters in another district, in our representative bodies, you obviously would have fewer people who are represented by one district and more people represented by another district. That's what we call vote dilution. And the United States Supreme Court said, we need to have population equality so everybody's vote counts the same, everybody's vote matters the same. So we require population equality among districts. As I mentioned just a minute ago, that applies to our congressional districts. We have 8 of them in Wisconsin. We elect 8 representatives to the United States House of Representatives. So this equal population idea, one person, one vote, it applies to our congressional districts. It applies to our state legislative districts. In other words, our state assembly and Senate districts. And it also applies to our local government districts, such as aldermanic districts, which we'll get to in just a little while as well. So one person, one vote, population equality. Well, we have the federal census every 10 years. We had the last census last year in 2020. Before that, the previous census we had was in 2010. And so because those populations change among the districts, people are born, people die, people move in, people move out, we rebalance those populations among the districts every 10 years and the year after the census is taken so that we can equalize the population among districts. So that's why we redistrict every 10 years. So who actually does this? Who actually redistricts? Well, for state legislative and congressional districts, at least, it's the state legislature, the 2 chambers in the Assembly and Senate that have the first shot at redistricting, passing new legislative districts. And actually in Wisconsin, we don't call it redistricting. That's sort of a name that everybody uses. We actually call it apportionment. So what the state constitution requires is that the state legislature apportion the districts anew in each year after the census is taken. So that means that the state legislature, in the first instance at least, has the responsibility to pass legislation adopting new state legislative and congressional districts. Even though the congressional districts are used to elect representatives to the United States House of Representatives, obviously not a state institution, but a federal institution. Nonetheless, it is the state legislature that's responsible for drawing those districts as well as the state assembly districts. Once those districts are adopted by the legislature, if in fact they do agree, if both houses of the legislature are controlled by the same political party, they typically do agree. If they're not, then they don't agree, and we don't actually have that legislation. Once those districts are passed by the legislature, they then have to be presented to the governor for the governor's signature or the governor's veto. We have something in the Wisconsin Constitution called a presentment clause. And that says that when we're making laws, the bills that are passed by the legislature have to be presented to the governor for signature or for veto or for pocket veto before they can become law. So that has to happen for new state legislative and congressional districts to become law. If they can't agree, if the governor vetoes the districts adopted by the legislature, or if we've got different political parties in control of the 2 different chambers of our legislature, then we have what we call an impasse situation. And if there's an impasse, then it goes to the courts to decide on what the districts should be. Now, how about county and municipal districts? So what about our local districts that I know Jason's going to address here shortly? Well, it's a little bit I want to highlight a change that was made to understand it a little bit better. So before, and I'm going to use as the dividing line 2011. So before 2011 and going back a long ways in time, municipalities drew our wards. So we would start off the whole process of redistricting in the municipalities with the municipalities. And there were some requirements that we had in our laws about what wards needed to look like. But the main point I want to make is that wards would draw them first, and they would draw them based on sort of physical boundaries, where people live, where we have what are called communities of interest. In other words, people who have common interests and need to be represented by a common representative. So, for example, in a neighborhood, you might say, where I live, Dudge and Monroe, you might say, well, that's a natural community of interest, and those people should be within the same ward. So that's the way that it worked before 2011. Municipalities would draw the wards first. They would then take those wards and they would pass them on to the counties. And the counties would then use those wards drawn by the municipalities to draw their county supervisory districts. And then that would all be given to the state legislature, and the legislature would use those wards as the building blocks to build the state legislative districts. That's how it worked before 2011. Now, what happened in 2011? Well, the legislature passed a statute called 2011 Wisconsin Act 39 in 2011. This came right in the middle of when the legislature was adopting new state legislative and congressional districts. Now, this is an issue that I tried to a federal court in Milwaukee in 2012 when we challenged the new state legislative districts that were adopted in a statute called 2000 Wisconsin Act 43, and I'll just refer to it as Act 43. Act 43 were the new state legislative districts, and those state legislative districts worked a massive change from the legislative districts that had been adopted in the previous decade. Going back to 2002, there was a federal court that had adopted new state legislative districts. So it was a court-drawn plan. In 2011, as everyone will recall, we had unified control of the state legislature and the governor's office. The Republican Party of Wisconsin controlled the legislature and controlled the office of the governor as well. So they could pretty much do whatever they wanted to do as far as the legislation is concerned. What they ended up doing was to adopt districts that were intentionally slanted in the Republicans' favor. I was also part of a legal team that challenged that in a partisan gerrymandering case called Whitford versus Gill that we took to the U.S. Supreme Court in 2017. But if you think about it this way, if you get the census data, which are released by the U.S. Census Bureau on March 31st, following the year that the census is taken, so that would have been March 31st of 2011 when those census data were released. And if what you want to do is work a gerrymander, political gerrymander, partisan gerrymander to favor one political party throughout the state, it's pretty hard to do that if you're going to have to base your state legislative districts on wards that are drawn by municipalities. So if Milwaukee and Madison and Wausau and La Crosse and Green Bay, if they're all drawing their wards in the way they want them to be drawn, then you're kind of cabined by what they do. And so it's pretty hard to draw as much of a gerrymander as you want if the municipalities are in charge of drawing wards. So what did the legislature do? Well, it conveniently passed this statute, this 2000 Wisconsin Act 39, and it had two key changes. First of all, this statute required wards to be based on whole census blocks. Now, a census block is the smallest unit of measurement that the Census Bureau counts a population in. And so they generally are roughly in size between, and this is roughly in size between typically about 1,000 and 3,000 or 3,500 people or so, something like that. But remember, before 2011, wards could be based on those criteria that the municipalities decided. Now the legislature said, no, wards have to be based on entire census blocks themselves. In other words, municipalities lose the ability to be able to determine what the boundaries should be in part to the extent that they don't follow the census blocks. So the municipalities lose control of those. But the other important part of that is with wards having to be based on census blocks, and the census blocks and their data being released on March 31st of the year following the census, the legislature no longer needs to wait for the municipalities to draw wards first, because the census blocks themselves are the building blocks. Those are determined by the Census Bureau, and everybody gets those at the same time on March 31st. The other key change that 2011 Wisconsin Act 39 made is that it provides, and it still provides, that wards cannot cross state legislative district boundaries, and they have to be adjusted if they do. Now, this applies to state legislative districts. It doesn't apply to aldermanic or supervisory districts. So, I'm sorry, it applies to wards, not aldermanic or supervisory districts. So in other words, what this means, the practical impact of this is that if municipalities, in drawing their wards, if those wards conflict with the state legislative district boundaries that are drawn, then the state legislative district boundaries take precedent, and the municipalities have to adjust their ward boundary lines. So now what happens as a practical matter after 2011 by statute is the first step in this process of local redistricting is that the county has to prepare a tentative plan within 60 days of the release of the census data. And that's also listed by statute as being July 1st at the latest. Now, remember, these dates are going to be premised on a release of the census data as of March 31st. This year is a different year, and the problem is that the census was really terribly done last year, unfortunately, and because of that, the Census Bureau required some additional time this year to be able to actually put the data into a meaningful format and have the data vetted in a proper way. So the census data weren't released this year for the purposes of state legislative districting and local districting until August 12th. So these deadlines that you're going to see in here, these time deadlines, which are in the statutes, in the Wisconsin statutes, actually just are out the window this year. Everybody's trying to do this as quickly as they can, and mostly on the local level, trying to comply with the December 1st timing for candidates to begin to circulate nomination papers, which is why we've been scrambling to do this at the municipal and the county level. But in a normal year, or if there is such a thing anymore, or assuming that, that the census data are released by March 31st, then by statute, the county would prepare a tentative plan within 60 days of the release of census data. So they're going to provide, the counties are going to prepare their tentative supervisory districts. They then give those to the municipalities, and within 60 days of that, the municipalities are supposed to draw their wards and adopt their wards and notify the county. Then those wards go back to the county, and the county has 60 days to adopt a final plan. If there's conflict among those two, that can go to a court to decide. And in fact, in 2011, I tried a dispute representing the city of Kenosha, where we sued Kenosha County because they couldn't agree on what the legislative districts, or the wards, I'm sorry, and the county supervisory districts should look like. That's the way that the process is supposed to work now, so everybody understands it. And as I mentioned before, if the ward boundaries that are adopted, and remember, this is done pretty early in the redistricting process as well, so they're typically done by December 1st, so we have wards in place, aldermanic districts in place, county supervisory districts in place, so that people can circulate nomination papers beginning December 1st. So that usually happens earlier, and then the state legislative districting usually happens later in time. It usually doesn't happen until sometime after that. And so by statute, if those ward boundaries adopted by the municipalities conflict with the state legislative district boundaries, then the municipality has to adjust its ward boundaries by April 10th of the second year following the census. What that means this year is, let's say that City of Madison adopts ward boundaries, and we've got them in place. And then lo and behold, once we have final state legislative district boundaries, if any of the ward boundaries conflict with those state legislative district boundaries, the City of Madison will have until April 10th of 2022 to adjust our ward boundaries in the city. Okay, so what is required when we draw districts or maps in in Wisconsin? Sorry about that, Milwaukee native here. So let's first take a look at the state legislative districts. And this is historically what has been required when the legislature is drawing these districts. Well, as I mentioned before, we've got this one person, one vote, equal population requirement. For congressional districts, the Constitution, as the law holds, the Constitution requires perfect equality. So because the federal Constitution, the US Constitution requires perfect equality among congressional districts, all of our 8 congressional districts actually have the same population down to the individual person. They have to be identical. There's a little more leeway that's allowed for state legislative districts and then other districts that are a little bit smaller in size. It's a lot easier to balance out the population among larger districts than it is among smaller districts. And so courts have held presumptively that population deviations from the smallest populated or least populated districts to the highest populated districts, if that deviation is 10% or less, then presumptively those districts are constitutional. As a matter of fact, it's actually, in practice, it's actually much easier to get, it's pretty easy to get population equality down in the 2%, 3%, 1% range. And that's more typically what our, among legislative districts, the kind of population deviation we've seen, something more in the 3%, 2%, 1% range. So that's pretty easily met these days, but that is a legal requirement. Districts also need to be contiguous, which means that they have to be, they can't be split apart. You can't have part of one district in one part of the state and part of one district, the part of the same district in another part of the state. They have to be physically kept together. That's a little bit more complicated in Wisconsin because we have these municipal islands that we occasionally get. Sometimes you'll see some districts where it looks like it's an island and you say, wait a minute, Poland, you told me that they have to be contiguous. They do, with the exception of some of these small municipal islands that pop up. But for the most part, they really are all contiguous. They're required to be as compact as practicable. By that, we mean when you look at them in terms of the shapes, we don't want them to be strung out in sort of long, skinny lines, or we don't want them to be, have kind of tentacles that reach out in different directions. We want to look at them and we want to see that the shape is kind of a regular shape, a square, a rectangle, or something that looks kind of like that. There are different scientific ways that the political scientists have come up with of measuring compactness that have different names I won't bore you with. So it's not like this is a wholly subjective criteria. It can be objectively determined and equally applied. But that's the text of the requirement in the state constitution, is that they be compact as practicable. And then the districts also are required to keep political units such as wards, municipalities, or counties intact when possible. Now, the contiguity, compactness, and preservation of political units, those 3 requirements are in our state constitution. Those come right out of the state constitution. So you've got the equal population requirement at the top that comes from the federal constitution. Those next 3 bullets come from our state constitution. Then the next bullet down, districts have to comply with the Voting Rights Act of 1965, and in particular, Section 2. Section 2 of the Voting Rights Act of 1965, in essence, requires districts to be drawn to provide opportunities to minority communities to elect representatives of their choice when it's possible to do that. That sounds like a lot of word salad probably, but basically what we're trying to do is we're trying to prevent the dilution of the rights of communities of color to elect representatives that they want to choose. Not surprisingly, there is a long history of discrimination in the United States, and that's what caused the passage of the Voting Rights Act of 1965, where white voters would band together to drown out the election choices, the voting choices of, in particular, African Americans in the United States, and increasingly that has applied to, I'm going to call them Hispanic voters because that's what the Census Bureau calls them, but you can call them Latinx or Latino if you want. But the census data call them Hispanic voters, and that's the term that's used in the case law as well, in the legal cases. So basically, when we look at districts, if it's possible to draw a district where in a way that we can give an opportunity for Black or Hispanic voters to elect a candidate of their own choosing, the Voting Rights Act of 1965 requires that we do that. That happens mostly in the Milwaukee area. So you've got to have a significantly large population, minority population, to be able to draw these districts. We call them opportunity districts. It doesn't have to be a majority of voters. Okay, so you don't have to draw districts ultimately that would have a majority, let's say 51% Black voters and 49% of other races. It just means that, and there's a very technical analysis that has to be performed with this that we call a racially polarized voting analysis. It gets quite technical, and we retain political scientists to do this for us. But you've got to be able to draw a district that will perform. In other words, when we look at the election data, when we look at the population data, you need to draw the district so we can be reasonably assured that the voices of the minority voters in that district won't be drowned out by a white majority. And then the final requirement of state legislative districts is they have to comply with other federal constitutional requirements, which typically are found in the Equal Protection Clause. So for example, you can't engage in racial gerrymandering. You can't intentionally pack so many or put such a large percentage of a district made up of a specific race and using that as your primary criteria. That is barred by the federal Constitution. Those are the legal requirements. There's one, there are other things that we call traditional redistricting criteria. The most important of those is probably communities of interest. It's something that I mentioned before. This is a very subjective criterion. It really isn't defined anywhere other than the idea that people with common concerns should be represented in the legislature or in the Common Council or whatever by a single representative. So like I said, Dutch and Monroe, we have common concerns here, common interests. We should be represented by the same alder. When we look at state legislative districts, we might say, well, the city of Whitewater, those people all have common concerns. They should be within one state legislative district that's a community of interest that shouldn't be split. So those are the criteria that we look at for state legislative districts. There was a little bit of a change there to that, at least with respect to how the state Supreme Court is going to adopt districts this year in this go around. Now this is a change in the law that was worked by an opinion that they released just last week on Tuesday. And the state Supreme Court is going to decide what the districts are going to look like. This is the first time it's done that since 1964. This has been handled by federal courts in each of the previous decades, from the 1980s at least up until this past decade. The federal courts apply the criteria that I just walked through a minute ago. The state Supreme Court now is taking a different approach. The state Supreme Court has decided that it will implement judicial remedies. In other words, it's going to decide on new maps only to the extent necessary that the districts as they exist from Act 43 adopted in 2011 are no longer compliant with the law. So if we don't have districts that are compact, if we don't have districts that are contiguous, if we don't have districts that are equally populated, if we don't have districts that comply with the Voting Rights Act, then the state Supreme Court has said those will need to be changed. And this then jumps down to that sort of the third bullet point, but they need to be changed in the smallest possible way to remedy those legal violations. So this is what they're referring to as a least change approach. And the court said that it will not consider the partisan makeup of any districts because there is no cognizable right under the Constitution, either the federal Constitution or the state Constitution, to have anything, to have partisan fairness. So they're going to turn a blind eye to what the partisan impact might be of plans that are proposed. And I'm going to go to the timeline for that litigation in just a minute because that's probably an area of interest. What about traditional redistricting criteria under this new framework that the state Supreme Court has adopted? Well, Justice Hagedorn wrote a concurrence. The decision, by the way, there was a three-justice, what we call plurality opinion. It was written by Justice Rebecca Bradley. It was joined by Chief Justice Ziegler and Justice Roggensack, and then Justice Hagedorn wrote a concurrence. Concurrence means that he agreed with the judgment of the court, and he joined in much of its opinion, but he also wrote this separate concurrence to make another point. And then there were three justices in dissent, Justices Karofsky, Dallett, and then Ann Walsh Bradley. So in his concurrence, Justice Hagedorn said, yeah, I agree with what Justice Bradley wrote, but I do think that also that in adopting new districts, we need to look at communities of interest. Then there's this other, what sometimes is called disenfranchisement in our state Senate votes, but it's really sort of delayed voting. We have 33 Senate seats. We vote in Senate elections, they're staggered. So we vote in 2020, we voted in half, or 16, I think it was, of the state Senate elections. In 2022, we'll vote in the other 17. And so it alternates. And so you get this sort of disenfranchisement potentially that's kind of complicated to explain, but it has to do with that. And Justice Hagedorn said, I think those things can be considered as well when we're looking at adopting new state legislative districts. But Justice Hagedorn put an exclamation point on the partisanship point and said parties should not present arguments regarding the partisan makeup of proposed districts. So they are not going to listen at all to any arguments that would argue in favor of partisan fairness for the state legislative districts. Now let's talk about local districts and wards in particular. What about the criteria for wards? Well, a lot of these are going to sound familiar, and there are a couple of differences. First of all, there actually are statutory minimums and maximums for our wards under the Wisconsin statutes. And those are dictated by the size of the municipalities. For municipalities above, I think it's 150,000 residents, their wards have to have not less than 1,000 or more than 4,000 inhabitants. That can change a little bit. There are a couple of exceptions to that can come into play, but that's the general rule. So for each ward in the city of Madison, you got to have at least 1,000 people in there, but you can't have more than 4,000. So that's something that when we're drawing our wards, we've got to work around. That's just one of the legal requirements. Again, wards, aldermanic and county supervisory districts have to comply with the Voting Rights Act of 1965. And so when the Common Council is looking at the way that our aldermanic districts or our alder districts and our county supervisory districts on the county level, when the county supervisors are looking at those districts, they've got to keep in mind the Voting Rights Act of 1965. The fact of the matter is that the populations that we have of Native Americans and African Americans and Hispanics in Madison, in Dane County, they just aren't large enough actually to be able to draw these kinds of opportunity districts that are required by Section 2. Milwaukee is really about the only area of the state. Racine potentially, but Madison, we're not quite there yet, where Section 2 really comes into play. Again, wards have to be made up of whole census blocks. Wards have to be contained entirely within one county. So all of our wards have to be within Dane County. Not a big deal, pretty easy to accomplish. But for those municipalities that border Dane County and one of the other counties, that can come into play. Wards have to be compact and contiguous. Again, two other requirements that we talked about before. And a little bit differently, this is written into the statutes, wards do need to respect communities of interest. So that's not just one of these sort of traditional criteria that maybe can be considered like it is in state legislative districts. It actually must be taken into account when drawing wards. There are a variety of different grounds that we can use to challenge districts. So in state courts, we can bring claims under the state or federal constitution, state statutes and federal law as well. In federal courts, we can bring claims under the Voting Rights Act. We can bring claims for racial gerrymandering under the Equal Protection Clause of the First Amendment. But one thing we know we can't do, we cannot bring partisan gerrymandering claims in federal court. That was decided in 2019 by the 2019 by the U.S. Supreme Court in a case called Marucho versus Common Cause. So we cannot bring partisan gerrymandering claims in federal court. Of course, there are always legislative options. The legislature could put into place, get the ball rolling, at least in a constitutional amendment that would require fair districts to be drawn in a fair way, districts to be drawn by a nonpartisan redistricting commission. That could be done, or there could be laws that could be adopted that would have somewhat of the same effect. There also are new federal statutes or federal bills that are pending that would require fairness to be considered, partisan fairness to be considered, at least in the congressional redistricting process, but those are stalled in Congress right now. So there are legislative options that are available. but the state legislature has not chosen to take advantage of those, and bills are stalled in the Senate and the U.S. Congress right now. Just very quickly, in previous decades, as I mentioned in the 1960s, that's when we had these one person, one vote cases. That's when the current framework really went into place. 1964 was the last time the state Supreme Court decided on what the state legislative and congressional district should be. In 1970s, we had an enacted plan. In other words, the legislature and the governor agreed, and there was no court involvement. But in the 80s, 90s, the 2000s, and then the last decade, the federal court was involved in deciding all of those. This year, however, we have reached an impasse. So we have the legislature that adopted what it wants to see as state legislative districts and congressional districts. The governor vetoed those. That happened just last month. And there is litigation pending in the federal court. There's a group of voters that filed a federal court action in the federal court in Madison on August 13th. A group of nonprofits, organizations, and voters that I represent filed a case on August 23rd in the federal court. We alleged a Voting Rights Act violation with respect to Milwaukee districts. That case right now has been stayed by the federal court. We do have a trial date of January 31st, 2022. It's reserved for trial, but that case has been stayed or kind of put on ice by the federal court while it plays out in the state Supreme Court. And so in the state Supreme Court where we are right now, and I'm going to kind of jump down to the bottom of this, on December 15th is when the parties all have to submit proposed state legislative districts. There are 9 parties to the case. Again, my nonpartisan, nonprofit, nonpartisan clients, Black Leaders Organizing for Communities, Voces de la Frontera, League of Women Voters of Wisconsin, and the number of voters of those are the parties that I and my team represent, will be submitting maps. Other parties will be submitting maps too. The governor, the legislature, the Republican congressman, a number of other groups are parties to that case. So December 15th is a date to keep an eye on. That's when we submit these proposed maps to the state Supreme Court. There is going to be a flurry of papers filed by the parties. Then in the month of December and early January, and January 18th is what the state Supreme Court has set aside for a possible hearing or trial, or maybe it will just decide and issue an opinion on what those districts might be. Caveat here, notice that I said that the federal court has reserved January 31st, 2022 for trial. That is because we have claims pending in the federal court for violation of federal law. And if what the Wisconsin State Supreme Court adopts in terms of state legislative districts, if those still violate Section 2 of the Voting Rights Act, then we are going to seek to have our trial in federal court and have the federal court decide on what the districts should look like, at least with respect to those Milwaukee area districts that are implicated by the Voting Rights Act. So that's something to keep an eye on as well. And then very quickly, just a timeline. As I mentioned in August, that's when we received the redistricting data. It was delayed for March 31st. December 1st, so just a few days ago, last week is when the spring election candidates were eligible to begin to circulate their nomination papers. April 5th is when we have our spring elections. April 10th is the deadline for municipalities to adjust their wards. That's what I referred to earlier, if those wards conflict with state legislative boundaries as they're eventually adopted. April 15th of 2022 is the first day to circulate nomination papers for the partisan primaries that occur in August. June 1st is the deadline for those nomination papers. We have our partisan primaries in August and then the general election next November. So that is redistricting in a nutshell. I'm going to stop my share now and come back out and happy to answer any questions people have.
Wow, Doug, that was fantastic. Very thorough. Very much appreciated. I learned a lot. We do have one question already. We can, if anyone has other questions, just raise your hand. We can see everyone on one screen here. Matt asks, Doug mentioned this year's census was, quote, horribly done. Can you explain why or what the causes were? Was it due to logistical difficulties stemming from pandemic? Was it political posturing?
There were a whole lot of things going on there. So it absolutely, the pandemic was a big problem. We know that. We had the backdrop of the hostility toward immigration policy and toward immigrants generally that was largely viewed as having a pretty significant impact on counting of immigrant populations and Hispanic population in particular. When you've got people who are afraid they're going to be deported, caught and deported if they fill out a census. And the important thing about the census to note, and this is in the US Constitution, this is settled law. The Constitution requires for the census the counting of all people. It doesn't require the counting of all citizens. It's all people. It's everybody who lives here, regardless of whether they're a citizen or not. But of course, if you're not a citizen and you're concerned that the people knocking on your door might be ICE and they're going to take you and they're going to jail you and they're going to deport you, you're much less likely to answer the door if the knock is from the Census Bureau. So there is a pretty dramatic undercount. People believe, it's not been demonstrated yet, but people believe there is a pretty dramatic undercount of Hispanic voters in particular. The pandemic was certainly a part of it. We've got that issue with immigration. And then there was also just the general hostility to counting citizens, and there was a lot of sort of hullabaloo around this question of citizenship with the Trump administration and the people who put in front of the census, or in charge of the census, as trying, at least walking up to a point of trying to exclude non-citizens from the census count. So all of those things together, the census it was supposed to be, it was also truncated prematurely, it was cut off. And so when the new administration came in January and was trying to look at the census data, there were a lot of adjustments that had to be made to the census data.
Thank you, Doug. Matt, and the next question was from Andrew. What is the case law background on what, quote, compact as practicable is interpreted to mean? Are current or proposed maps close to violating this definition?
Well, it's so although it is objectively criteria, there are no standards that are set by the courts. So the courts don't say, when we look at these different, there's a test called the REOC compactness test. There's another one called Polsby-Popper. These are just different ways of creating a numerical measure of compactness. And so typically what happens as a practical matter in these cases is you've got a number of different parties that are submitting maps. And so it's usually a comparison. Whose compactness scores are better than the other sides. And it goes into the total mix of information. So there's no court decision out there that says compactness score needs to be at least this and cannot exceed that. It's just usually done on a comparative basis. And compactness scores, we will typically use an average compactness score to compare the different proposals.
Thanks, Doug. Those are questions. Do we had anyone else question? Oh, Ron.
Good morning, Doug. Thank you for being here today. So I was wondering, Doug, if you could speak a little bit to the need for resources, financial resources, how some of this gets funded. And I'm going to make an assumption that one of the reasons why a nonprofit organization may have been created is so that people who are concerned about these matters and issues can find a pathway to provide our own financial resources to help out with this.
Yeah, absolutely. Thank you for the question, Ron. I appreciate it. Yeah, this is tremendously expensive litigation. This is among the most complex litigation I've been involved with in my years of practice, including at a very large multinational firm. I've been involved in sophisticated antitrust cases. I've been involved in sophisticated securities fraud cases, product liability, contract shareholder disputes, you name it. This kind of work is among the most sophisticated that we do as lawyers. And not surprisingly, and we have to have experts who help us out as well. Back in 2011, we spent, to challenge the state legislative districts, we spent well in excess of $1 million, and that has to be funded somehow. The state defending the maps that were adopted by the Republican majority and signed into law by Governor Walker spent $2.3 million. So obviously the resources of the state, when they're brought to bear this year in this cycle, the legislature a year ago retained lawyers from Washington, D.C. and Chicago to represent them and their interests, and they signed a contract that obligates them to pay well in excess of $1 million to those lawyers as well. So this is very expensive. One of the reasons we launched the nonprofit is it's just impossible for for any of us or any regular litigants who's going to go spend $1.5 million challenging these statutes. Like I said, we represent a number of nonprofits and a number of voters. We're able to do that because we have a nonprofit that's gone out, that's engaged in the fundraising, and it's raised the funds to be able to represent these nonprofit, nonpartisan groups. That's a rise that we've seen over the course of the past decade. We've seen a number of national, what we call nonprofit, nonpartisan impact litigation groups that have come into being in the past decade, specifically for the reason that Ron mentioned. People can't afford this kind of litigation; they just can't. But it's critical that it be litigated. So that's why we launched Law Forward last year. That's why we've been raising money to be able to engage in this kind of litigation. There are a number of national groups, like I mentioned. One of our attorney team in this redistricting lawsuit, we've got Law Forward, we have Stafford Rosenbaum, and then we also have another national nonprofit called the Campaign Legal Center. They were my co-counsel also in the Whitford versus Gill partisan gerrymandering case. And so they raise money on a national level to litigate nationally. We raise money nationally to litigate, Law Forward does, to litigate issues in the state of Wisconsin. But that's the need to raise this money to be able to engage in this kind of democracy litigation work.
Thank you.
Thanks, Doug, very much. Next question from Lincoln, and I agree wholeheartedly with this first statement. Thank you for making something very complex more understandable. So thank you, Doug. I've learned a lot. What role, if any, does technology play in drawing districts? Are algorithms brought to bear to make the process more objective?
Absolutely. And we saw this really for the first time last decade in 2011. We had to unpack this through the documents and the data that we discovered in the last go round in 2011, 2012. It really is all done algorithmically now. It's very sophisticated. We have a lot of data. We have election data. We have census data. We have very sophisticated software. We have very powerful computers. We can run regression, very sophisticated regression analyses to measure every aspect of these districts we're putting into place. Probably the most disappointing, I'm trying to refrain from making too many editorial comments here, but one of the most disappointing aspects of the state Supreme Court's decision from last week was it sort of pretended like we can't know if districts are tilted in favor of one party or another. And so, we just can't objectively determine that. That couldn't be any less true. What we saw back in 2011, because we took the discovery and we got all of the data, in fact, we actually got the computers and the hard drives that were used by the legislative aides who drew those districts. And what we found was that they kept on, they would draw proposed district lines. They would run them through an algorithm to test what the partisan impact would be of those districts. In other words, how many of the 99 assembly seats would Republicans be projected to win from those districts that they draw? So they'd run that analysis, then they'd recalculate, they'd change the lines a little bit, they'd recalculate it, change the lines a little bit, so they were ratcheting up the advantage. And the idea that you can't predict the outcome of an election or future elections from the districts that you draw is completely fallacious. How do we know that? Well, from those analyses that they did, we discovered what they actually did. This is pretty amazing. The Republican algorithm that they used in 2011 predicted that Republicans would win 48.6% of the vote in the 2012 election from the districts they adopted. Do you want to know what the percentage of the vote was that Republicans won statewide in the 2012 elections? 48.6%. They nailed it on the button. They predicted that they would win 59 of the 99 assembly seats in the state Senate. Do you know how many they actually won? 60. So they were pretty darn close. They also engaged in something that's called a swing analysis. So they did, again, this is very sophisticated statistical analysis. So they took a look at, they wanted to have very durable districts in their favor, not just that they would win one election, but they would last throughout the decade. And so they did the swing analysis where they said, Well, what if the overall vote share for Democrats swings? It increases by 1% or 2% or 3% or 4%. How are our districts going to perform on a partisan basis under those conditions? And they then tweak the districts to allow for that as well. And so that has allowed them, and what that analysis showed was that that Republicans could win a majority of the districts, 50 or more of the 99 districts, getting as little as, I think, 43 or 42% of the statewide vote. But that for Democrats to win a majority of the statewide vote would require a 57% vote share throughout the state. So absolutely, it is easy to gauge what's going to happen with these districts in terms of partisanship, and to pretend that because of these sophisticated tools that we have, and to pretend that we can't tell that is just it's a lie. Quite frankly, it's just a lie.
All right, I'm going to take a couple quick minutes here. Thank you. Any last questions for Doug? If not, I'm going to quickly go over what happened in the local elections here in the council. There we go. So here is a quick analysis of what happened. Again, thank you to Doug for all of your help on this. As you all know, the city council voted, it was late, about a month ago, to redistrict the city, which obviously Doug went over why that has to happen, how that happens in his presentation, his great presentation. But what were the actual political ramifications in the city of Madison for the 20 alder districts? You can see here, this is concept 7A, which is the concept that was used for the final maps that were approved by the council a month ago. And it made several changes and then put several alders into one district. So this is important for us as we look at our work next year, as we gear up towards the 2023, April 2023, next set of local elections for both mayor and alder seats. Also, there is a January, February primary, early February, sorry, in 2023. So this is important for our work moving forward. As you can see, several districts are now open. District 1, District 2, District 2, District 6, and District 14 do not have an incumbent candidate. Those incumbents have been moved to other districts. One of the criteria they used was to not pay attention to where the current alders were, and that clearly happened here. So in District 1, District Harrington McKinney was moved to District 20, which opens up District 1. District 20 was moved into District 10, several of our districts here, and now District 10 has 3 elected officials in it currently, Sherry Carter, Christian Alboras, and the current District 10 alder, Yannette Figueroa Cole. You can also see that District 2, downtown district, does not have a current incumbent in it. Patrick Heck is in District 6. District 6 is current alder. It's all very confusing and all a lot. Brian Benford was moved to the 15th, where Alder Foster currently is. Now, this is all subject to where people will live when they file. So some people could move based on it, but as of their addresses right now and where they live right now, this is the change. One other note here, I think it's very important, is the population changes in the city of Madison. The growth was significantly in 2 areas, on the far west side, and then most importantly for us, in downtown. The largest growth was in downtown. In fact, the 4th district gained the most residents over the last 10 years. District 4 added, I think 6,500, 6,600 residents, which is 50% over at what the alder district should have been at that time. There's been 16% total growth within the city, and a vast majority of that happening here in downtown. So what we had is reconfigured downtown districts. We now really truly have 2 alders that are the center isthmus, District 4, which was Alder Revere, the Capitol Square, the near west side, and then the Mansion Hill, sort of northern, part student, part Tenney, Lapham district. District 2 is actually the tightest district in the city. District 4 is not, because of so many Capitol grounds and government buildings and population base not being in the center of downtown. But this is, really an interesting change for DMI that we're watching. That you now have 2 really center city alders. Plus, the 6th district was a dramatic change. The 6th district used to be the Marquette neighborhood, kind of kicking towards the near to mid-east side. Now it is a isthmus in Tenney Lapham neighborhood and Marquette. So very much a downtown alder seat as well. It continues to be an alder seat. downtown, which is the student district, and then the 13th as well, which leaks into the near west side, Alder Tag Evers. So these are the significant changes we saw over the last redistricting. So I just wanted to go over that quickly. I know I've been following along with the chamber, Bill at Smart Growth as well, but just wanted to go over that as well. Anyone have any questions about the redistricting here in Madison? All right, I guess, Doug, everyone has questions for you and no one has questions for me. You can't win them all. You can't win them all. Excellent. Well, we hit it right on the dot with timing. A huge thanks to Doug for the excellent presentation. Kudos to you. I second to what Lincoln said about how you made something very complex, and as you said, the most complex litigation you've ever dealt with, into something that much more digestible for me. So I learned a tremendous amount. Thank you for your time and that as well. Our last couple of quick announcements before I give our last word to Angie. We've got several events that you all might be interested in. Tomorrow we have our last MSN Madison Milwaukee Downtown Exchange event, our last of the year. We're going to have another one here in January, but our last of the year. It's going to be about big ideas. We've got speakers on big ideas in buildings, big ideas on how to bring community together, big ideas in retail. Join us tomorrow, 8 o'clock. Sign up at www.downtownmadison.org. And then the 16th, we've got a tremendous amount of events on one day, 3 events in one day. So spend the entire day with DMI. At 8:30 in the morning, we have a virtual important presentation from our friends at Michael Best on navigating vaccine mandates and policies. This was moved from last week because of a conflict last minute. Please do join us at 8:30. Really important information about what's going on with vaccine mandates. 9:45, we have our hybrid What's Up Downtown breakfast, which will be an annual review of the year. Always a great event. Please join us either at the Edgewater at 9:45 or on Zoom at 10 o'clock. And then last, but certainly not least, one of our last events of the year, besides a committee meeting or 2 and a board meeting, we have our New Faces, New Places at the last night market of the year. Yes, we will have fire pits to keep you warm because it's going to be outside at the top of State Street. Doug and I enjoyed the night market just a few weeks ago together. Next to the fire, literally, Vic and several of us were there. So please do join us at the top of State, 4 to 6 p.m., kind of near on the Ian side. You can't miss us. There'll be a couple of fires there. So literally, we'll send out a beacon for you to be there. So join us there for that. So thank you all for your support. Have a great day. And Angie, any last words for the committee?
No, I think we covered it. And thanks again very much, Doug, for doing this with us today. Greatly appreciate it. And thanks to everybody for attending. And if I don't see you before then, everybody have a happy holiday and a great new year.